Oh. All right.
How are you, Counselor? We met one time. We met one time a couple of years ago, but then we spoke on the phone this year. Had a case together at G's office. That was the issue. I think it was fueling.
Actually, anytime you want to start.
Okay.
Yeah, that. Yeah.
All right. We're going to begin the hearing for Asha White. I'm going to start by reading a letter from the governor dated July 21st, 2021. It's to the Executive Council. Dear councilors, I am pleased to nominate the following person to the position of Associate Justice of the District Court Circuit. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. The nominee is Asha Z. White of Medford, Massachusetts, the great city of Medford. I don't know if anybody knows this, but that's where they wrote Jingle Bells. Which position was authorized by Chapter 206 of the Acts of 1988. I am closing the nominee's resume for your convenience. And before we start, we're going to take a moment and say a little prayer for Councilor Devaney's sister, who is, she told us this morning, is not in very good condition and isn't expected to survive. So we're going to take a moment in silence and pray for her for a moment. Thank you. All right, now that said, I'm going to introduce Councilor Jubenville.
Morning.
And Councilor Marilyn Petito Devaney, who's present. The other councilors will be here shortly. So we're going to start, Asha, with you introducing your family and friends that are here today.
Okay. Starting behind me is Sarah Joss, the General Counsel for the Office of the Probation Commissioner of Mass Probation Service. My mentee at the Attorney General's office, Widmeyer Charles, who's going to be starting his clerkship at the Court of Appeals coming up in a couple weeks. This is my oldest son, Amari White. This is my father, Clement White, my wife, Fabiola White, my longtime friend, Stisha Emanuel, my other longtime friend, Bethany Sirota, and that is Kaylee sitting there. Kaylee, give me your last name again. Kaylee Terabasi, who also works with my wife and Sarah Joss. So thank you.
Great. So we're going to start by calling your first witness, and that would be, well, we've changed the witness list, I understand. Is that correct?
Yes, sir.
So the original witness I had was Judge Gloria Tan, who's not available as of now. Is that correct?
That is correct, sir.
Okay, so who are we calling in her stead?
We're going to call Justice Geraldine Hines.
We are greatly honored to have the retired Justice of the Supreme Judicial Court, Geraldine Hines, and probably the greatest vote I've ever taken in this chamber. Certainly the proudest. You're welcome to sit down if you'd like, Justice Hines.
Thank you. I just have some brief prepared remarks. Members of the Governor's Council. No.
Oh, okay, all right.
I'm old.
Okay.
I'm old. I consider it a privilege and honor to appear before you today to support the nomination of Attorney Asha White to the District Court. And I congratulate Governor Baker and Lieutenant Governor Polito for placing their confidence in this outstanding nominee. Attorney White asked me to speak on his behalf, and I'm happy to do so. Not out of some sense of duty, but with enormous enthusiasm and pride. I genuinely believe that he is superbly qualified for the bench and that the people of the Commonwealth will be well served by his presence in the District Court. I can speak enthusiastically in favor of this nominee because I have watched his career developed since I first came to know him as a law student on co-op from Northeastern School of Law. I was a new judge then, almost 20 years ago. but I remember him as a smart, hardworking student who took the commuter rail every day to Brockton, where I was then sitting. Reflecting on all that Attorney White has accomplished in his 16 years as a member of the bar, I believe that he is exceptionally well qualified to be a judge on the district court. He has a depth of experience that few others can claim, and I know that he will bring a wealth of qualities, both personal and intellectual, to the task of judging. I believe that I can say without fear of contradiction that he is knowledgeable on the law as demonstrated by his accomplishments in every position he has held. He will bring an enviable work ethic, an honest humility, and a youthful vigor, a quality that is highly underrated, in my opinion, to the task of judging. He is compassionate, and most important of all, he has distinguished himself as a person with a deep and abiding commitment to our country's aspiration to equal justice under the law. I must say also that I and other members of the bar and judiciary celebrate this nomination as a victory in the quest for a more diverse judiciary. But while we emphasize our concern for diversity, we do so with confidence that Attorney White is worthy of the honor of being nominated to sit as a judge on the district court, diversity notwithstanding. Let me close by saying that in my humble opinion, this nomination is richly deserved and long overdue. I have been among the many judges and members of the bar who have over the years encouraged Attorney White in his aspiration to serve on the bench. I am so happy that he persevered and that his nomination is finally before you for your consideration. Thank you for giving me the opportunity to speak.
Thank you, Justice Hines. Counselor Devaney.
First of all, a witness here. No. Now that it's turned on, my responsibility is to ask the witness what you know about the nominee. But I would be remiss if I didn't talk about this outstanding witness who I call friend. It'll be 21 years in the coming January. She's a role model, and when she talks about diversity of this nominee, she's the poster child for diversity, that's for sure. When I think of Justice Hines, I think of her growing up in Mississippi, being the youngest of, were there 10 children? 10 children. And her mother knew that education was important. So she sent little Jerry, 4 years old, to a teacher's home every day. And this was in the Jim Crow days. You can imagine what she lived through. Now, amazing, she became a lawyer, and she was in Massachusetts. And I don't want to embarrass her, but I want to tell her about just, I'm sure there were many instances like this. But when Justice Hines was in court, there were 5 lawyers with clients before her, and the judge called on all of them, and she was last. And when she went up to the bench, the judge said, "Show me some proof that you're an attorney." So she knows how important it is to have a judicial system that is fair and just and non-prejudiced. And I can't tell you what it means to hear your testimony for this nominee and what a tribute it is to you, Attorney White, to have this remarkable person speaking for you. So having said that, and I've completely embarrassed you.
Yes, you have.
Tell me, what qualities did you observe when you saw Attorney White in his, as a attorney?
Well, the thing that impressed me most, which I said in my statement, was getting on a train, a commuter rail, not the T, but the commuter rail to come to Brockton from Boston every day as a co-op student. Who does that? And the devotion that he showed to learning the craft of lawyering, watching the lawyers in the room, learning from me. I didn't know nothing from nothing because I was just 2 years on the bench, but we helped each other. And I was impressed from the beginning that this young man had a very bright future ahead of him. And we haven't talked much over the years, but whenever I've seen him, I've always said to him, I support you in your ambition. Let me do whatever I can to help you, and I'm just thrilled to be here.
Well, we're proud to have you here. So, you know, when you look at the system now, you think they're doing better in diversity,
I'm not happy.
right?
I'll be honest with you.
Yeah, I'm not either.
I'm not happy.
Yeah, and you know what?
But it's not your fault.
No, it
because,
isn't. It isn't.
You know,
It isn't.
the nominees come from the governor's office. They
That's
don't
right.
come from the council.
And I don't vote for all of them. If they're not qualified and experienced, I'm not going to vote. I'm not going to
totally
vote for
get
the
that.
next door neighbor of the governor, you know?
I totally get that.
But
It's diversity is an aspiration. And it's something that we have to continue to strive for. This is a first step. It shouldn't have taken Asha White this long to be nominated. You know, I read his application. This is, I think, the third time
amazing. Yeah,
that he's applied.
right, right.
And
But I do want, I'm going to interrupt you because I want to tell you one more thing to embarrass you in my 21 years that we've been a friend. When I voted the third time for you to be in the SJC, I remember exactly what I said.
okay.
And I said, we're only going to have Justice Hines only 5 years, but it'll be the best 5 years the Commonwealth of Massachusetts ever had. I remember saying that, and it's true.
My best counselor.
And we have talked over and over about this ridiculous age of 70 to retire, and we lose a hero like you. It's so wrong. I keep lobbying. I don't have the authority, but I'm going to keep trying.
Well,
because
you
it's
don't get any
wrong.
complaint from me about the
I
age
kn-
70 retirement.
I know, I
don't think we
know.
get a complaint from any of the
We
trustees
have,
about
we have
70.
talked about that so often, but I want to tell you, you still have that open invitation to the diner. And I look forward to that meeting again. Thank you so much
Thank
for
you.
coming.
Thank you, Judge Hines. Anybody else have any other questions, Justice Hines?
It's
Counsel
great to
Hoover?
see you. Always a pleasure here. I think your batting average is 100 here.
Well,
You've never lost.
don't disappoint me today.
We won't.
Okay, thank you.
We're all disappointed in this chamber at the lack of diversity on the bench. It's something that I've had
It's not your fault.
many conversations with the
Yeah.
nominee about, as well as other folks in this chamber. And it's something we're working towards, certainly. I can assure you of that, Judge.
I
And Judge,
appreciate that.
I just want to leave you with this. There's always recall. And you can go back to your home on Superior Court.
No,
I
wait,
want to
no.
introduce Judge.
Not
Counselor
SJC.
Duff that's
I'll have to
Yes.
stop
present.
promoting to judge.
Yes, Counselor Duff,
I'm
how are
going to
you?
have to work till past 70 anyway, so it doesn't matter.
Yeah.
Me too.
Thank you for coming. You know, I'm a big admirer. It was great to see you last week when you came in chambers as well for the last appointee who was here. Thank you for your service to the
Thank you.
Commonwealth. And I know the continued work that you do now, just in the community that may not be as apparent. I appreciate it.
Thank you so much. Thank you
And
for
before I
listening.
call you next witness, I want to acknowledge Judge White, who's here today, from the Superior Court. You put in for vacation time? Did you put in for vacation time?
Thank you, Judge.
Your next witness is Judge Tochka, retired judge of the Massachusetts Superior Court.
That would be the warm-up act.
tough act to follow.
Mhm.
So my sympathy goes out with your sister. I'm sorry.
Pardon?
I'm sorry to hear about.
Thank you.
So I want to thank you all for allowing me to come back, and I want to thank you all for voting for confirming me for a district court in 2000 and then for Superior Court in 2013. I appreciate that, and I hope I haven't let you down for that.
No, you haven't.
So I'm here to talk about Asher, and I just want to point out three things that I think are important. There's many things, but these three things stick out for me. One is having been a judge for 16 years. A lot of people come on the bench with different experiences. I don't think I've come across anybody that has the wealth of experience that Asher would have if he takes the bench. Obviously, people like myself who've had a experience for 16 years as a prosecutor, you lack the defense experience, you lack the civil experience, you lack a lot of experience, and you have to. And there's a perception, whether it's real or not, that takes place on the bench, and you try to correct that perception, or you try to be as fair as possible. But with Asher, I don't think I've come across anyone who's had experience as a DA in Suffolk County and in the Attorney General's office, has experience as a defense attorney, has experience as a bar advocate, has experience as a civil experience, has experience as a clerk in the second busiest court in the Commonwealth, and
Where you sat?
where I sat, and has experience as a teacher for over 10 years at Suffolk University. And that last part I think is very important, being a teacher, because as a judge in district court in the BMC, I can tell you that a lot of times you have new attorneys who come in, inexperienced attorneys who don't know where to sit, don't know where to stand, don't know how to present themselves to the court. And you're a teacher as a judge. And to have that experience for the past years with students and to be forgiving of people who sit in the wrong seat, who say the wrong things, is important, because that has a huge impact upon that person's future career as to how they're treated at the beginning. And I'll tell you, I wish that Chief Justice Dolly was here, because I'd like to comment in terms of my teacher in Superior Court was Eileen Gill. I don't know if many of you know, but that's his mother-in-law, and she was a court officer in Superior Court. And I could tell you, she was wonderful to me when I went up to Superior Court. She showed me where to stand. She showed me how to act. She showed me the decorum, how to act as an attorney, how to behave. And I've always thanked her every time. And every time I see the Chief Justice, I ask how his mother-in-law is doing, and tell her I said thank you. So I think all of those are important. Next, I just want to talk about briefly in terms of Asha personally. So as a judge in Dorchester, in BMC, West Roxbury, and Roxbury, I had him in front of me on numerous occasions. I had him in front of me as a DA in those courts. I had him in front of me in Superior Court. I had him in front of me as a defense attorney. And it's only if you're a judge that you recognize this, that when you sit on the bench, a lot of times you're paying attention to the room. And you could see, and not just the person who's in front of you. And it's interesting because the parties don't really know that you're making observations of them. And over the years, I've made the observation of Asha that he is a very sincere person. You could see that when he comes into the courtroom, how he immediately lightens up the room in terms of with the defense attorneys he's talking to, or the prosecutors he's talking to, talks to the court officers, greets the court officers, greets the clerks. And you could see he doesn't know that anyone's checking him out, anybody's watching him. That's who he is. He's just very relaxed in his own skin. He's very sincere. He's very compassionate when he argues. Obviously, he wouldn't be here, and I can confirm if he didn't have the experience as a trial attorney in terms of the law, in terms of the evidence. He has that. But he has more. He has the temperament that I think is very important as a judge. The last thing that I want to talk about is in terms of Asher, is he comes in terms of that's dear to my heart, is an alumni of the gang unit in Suffolk County. And it's interesting because there's something in the water in terms of if you're on that unit. And I mean that is because this council has seen fit to confirm over 20 prosecutors on that unit. There is no, who most of them were all, who then went on to become defense attorneys. And just like Asha, in reading his application, it reminded me of Paul McLaughlin. as to when he was talking about how he wanted to make a difference in the community, how he cared about the neighborhood, about how he went to live in the neighborhood, how he went to the meetings in the neighborhood, how he helped the young people, the students, the high school students and the like, in terms of to make a difference. And that was always the motto, particularly after Paul's murder, was to make a difference, to be there to make a difference for a community. And he is exactly the type of person that Paul would be proud to say that came after him. And you know, just in terms of that unit, you've seen fit to, at this point, there is now judges in the district court from that unit, the BMC from that unit, Superior Court, the appeals court, and the SJC. And so they all have in common Paul's desire to make a difference. And Asha exemplifies that. And so I can't but say that he is more than qualified to take the bench and more than qualified to make you all proud that you nominated, that you endorsed his.
Give me one second. Paul McLaughlin was a great man, and yeah, I considered him a friend as well. And his father was a great man, who at one time was the president of this council many decades ago when he was lieutenant governor. They were great people. Paul was a great man, and I just want to acknowledge that. And I agree with you in terms of how we feel about Asha.
Right.
Councilor Divinity.
Thank you, Councilor, for mentioning Paul McLaughlin. For people who don't know, he was prosecuting a known criminal, and he was shot down on a street in Boston. And he was everything you said. He really was. First of all, I want to tell you, I'm the only one in this chamber that voted for you 16 years ago.
Right, 16,
Yeah. And we're not any older, which is
Yeah,
so
well, you look the
amazing. But, you know, you've made me proud.
Thank you.
Because as I've always said, I don't have a crystal ball. And sometimes someone I voted for has let me down and hasn't done the right thing. You have never let me down. And we are all proud of the service that you provided for the Commonwealth. Unfortunately, the people that come through do not have the qualities that you have, I'm sorry to say. But today, I'm very happy. I don't have a poker face, and I usually don't say it at this point, but I'm very pleased with this nominee. And I'm especially pleased, I don't remember, you have to remind me, is this the first time you've been back?
No.
I'm trying to think.
Yeah, no, I've probably been in the, probably didn't see me in the back with all the other individuals.
Okay, but as a testifying,
I've testified a few times.
right,
Yeah.
right. Well, thank you, and I hope you'll keep coming, but believe me, your testimony means a lot to me. Now, I know you have seen Attorney White many times. Is there anything, any particular case that you saw him and it made an impression on you that you can tell us about?
So I could not point to the fact patterns of one particular case. Over 16 years, there's just so many cases, so many faces. But I can distinctly know that I've had him many times in front of me, and each time when he's turned to walk away, I've always been impressed by his demeanor in the court and by his honesty in front of the court. That means a lot.
You know, we don't hear that. We don't hear that attribute, honesty, and that's the most important thing that we should be looking at. And besides experience and qualifications, it should be honesty and then compassion.
Right.
That's how I feel. But it's so good to see you. I hope
Nice to
you're
see you.
enjoying your retirement in good health
Yep.
and with all your family.
I am. Thank you.
Thank you. Thank you for all your service.
Thank you.
Great to see you.
We'd love to see you on recall too, but do me a favor, don't tell Bill.
I'm upset. My grandson's keeping me
Don't let him
busy.
know about it.
When I told my grandson that I used to be a judge, he said, "You're not a judge anymore." 6 years old. I'm like, okay. Thank you very much.
Thank you.
Good
Thank you,
judge.
Judge.
Okay, are there any other witnesses in favor of the nominee? Are there any witnesses in opposition to the nominee? I know the doors of the State House are locked. Anybody want to check, see if there's anybody trying to get in? Okay, so we'll close the witness part of the hearing, and Asha, it's your turn. Tell us why we should vote for you.
All right. Before I begin, I want to acknowledge my longtime friend from college, Attorney Jamil Moore, who came in, and Judge Bill White. A lot of people think Bill and I are related. We're not actually related, but we might as well be. I consider him my unofficial big brother in my career, who let me tag along with him on very serious cases and learn the craft. Good morning to the council. First, I would like to thank the Judicial Nominating Commission, Governor Baker, Lieutenant Governor Polito, Attorneys Bob Ross and Lauren Green for this opportunity, and to the council for taking the time to interview me. Thanks also to my witnesses, Judge Tachka and Justice Hines, for speaking on my behalf today. My name is Asha White. I am the proud son of Clement and Jeanette Smith White, and a proud son of the Virgin Islands. Growing up, I never idolized athletes, musicians, or any famous people. I idolized my father and my father only. A man who started in a housing project on the island of St. Thomas, worked his way up to the Community College of the Virgin Islands, to his PhD from Brown University, all the way to becoming a tenured professor of Spanish and Latin American literature at the University of Rhode Island for 30 years. As a kid, he taught us about the difficulties of coming of age in a world that could be unfair and treacherous, and captivated us with stories of his time serving this country in Vietnam. He taught us compassion, to avoid emotional decisions and instead to use logic. He warned us of the danger of sanctimony and taught us not to judge another person until you have at least attempted to imagine walking in their shoes. If my father was my idol, my best friend was my mother, Jeanette White, a woman who worked away from a small village named Carrot Bay on the island of Tortola in the British Virgin Islands, to the Community College of the Virgin Islands, where she met my father, and also earned her PhD from Brown University and became a tenured English professor at Bryan College. She exposed my brother and I to the writings of Shakespeare, among others, at an early age, something that I've only learned to appreciate as an adult. She rarely spoke with her mouth, and instead with her actions and her efforts. Not only was she the brightest person I knew, she was also the most diligent. In the 4th grade, we had an assignment called the Rhode Island Report, where everyone in the class was asked to write a report about, you guessed it, the state of Rhode Island. Thank you. Since we were living in Rhode Island and owned an Encyclopedia Britannica collection, I didn't anticipate to be this a difficult assignment. When she gave me my first draft back, it was filled with red pen corrections, and I asked why she was so hard on me in this small report. She didn't say one word, and instead gave me an incredulous look that she was known for. In that moment, she taught me there is no such thing as a small assignment, and anything you do, you must give your full care and attention, something I took with me into my legal career. I came to Massachusetts in the fall of 1997, optimistic but not without hardship. My mother succumbed to cancer on November 3rd, 1997, 2 months into my freshman year at Boston College. However, but those scars turned into life lessons. The most important lesson I took with me was to be more empathetic to those who suffer through the several dark moments in their life, oftentimes without the guidance that I was provided, something that I also took with me into my legal career. In that legal career, I have had many titles: Assistant District Attorney, Assistant Corporation Counsel, Criminal Defense Attorney, Supervising Attorney for Suffolk Lawyers for Justice, Assistant Clerk Magistrate, Deputy Chief Assistant Attorney General, Adjunct Professor, and President of the Massachusetts Black Lawyers Association. I believe all of them have combined to give me the experience, perspective, and judgment to handle this awesome responsibility. However, in closing, I would say, my most important titles have been father and husband. I'd like to thank my son, who I call my big son, Amari Zaire White, who I carried in my arms at my law school graduation. And obviously I cannot do that now.
Try.
I look silly. My 8-year-old daughter, Avani Sahara White, and my 5-year-old son, Asir Zion White, who are both at camp today having a better time than us, who provide me with the inspiration to be a little bit better every day. And to my wife, Fabiola White, who, while handling her own legal career, for 16 years, has been there through every trial, every win, and every disappointment, and there were plenty. And she has been the ultimate steady hand in a career that has taken many unexpected turns, today among them. I thank you all for listening, and I look forward to your questions.
Before we start, I just want to say that you can see the pride in your family, especially your father there. And I'm sure your mother's just as proud today as we sit here.
Thank you.
Councilor Jubenville.
Yeah, thank you, Mr. Chair. Good morning.
Good morning, sir.
So, did you read the Harvard study commissioned by Judge Gantz?
I did, Counselor.
So, you would agree with me that the unfairness in the amount of minority members that are incarcerated in our Commonwealth.
Yes, I would.
So, me, people don't go to jail until a judge sends them.
Yes.
So it looks like judges are sending more people of minority backgrounds to our prisons.
Yes.
So you're going to be sitting on the bench. And how is Judge White, this Judge White,
Yes.
going to handle that issue?
Yes, Counselor. I've thought about that issue a lot. And let me say, when I read the report, I was deeply disturbed, troubled by the numbers that I saw, although you can observe things anecdotally. And while the report talks about needing to collect more data, I think it's clear that we have a problem in the court system and we have to start doing something about it. I think there are several things judges can do to mitigate the effects of conscious or unconscious bias. I think first, you have to have an expansive view of someone's life experiences when you're doing sentencing. First thing I would point out is I think judges have to be aware that people in certain communities across the state are more likely to come in contact with police. So you have to be very careful of judging someone solely on the record, especially for certain kinds of offenses. And the report breaks down different kinds of offenses: motor vehicle, sex offenses, offenses against property, drug offenses, et cetera, especially with motor vehicle infractions and drug offenses, because many people in certain communities are much more likely to come in contact with police. They're then much more likely to be arrested with those sorts of things. We know that drug use is equal amongst people regardless of race, but minorities are certainly greatly overrepresented in those arrests. And it's largely a product of coming into more contact with police. And I certainly would be conscious of that and consider that. I think along those same lines, when you're looking at a record, one of the things the report talks about in great detail is a lot of the issue comes down to the initial charging, that people of color tend to be charged with the more serious offense. There are many options when you charge people, and they tend to be charged with the more serious offense, and that leaves them in a negative plea bargaining position as the process goes on. So when you're looking at a record and you're seeing serious charges, you have to be mindful that sometimes that can be the result of that, especially, again, with certain kinds of offenses. In addition to that, if you're a judge and you're the one doing the sentencing, you have to be aware, and I know this from my time, especially as a prosecutor and as a clerk magistrate, for the same conduct, there's a slew of charges that the police or prosecution can apply for or move forward with. And for certain kinds of charges, it covers several different kinds of conduct. And just because someone is charged with the most serious or the more serious offense, you have to be mindful that you want to consider the conduct itself, not just be sentencing on the seriousness of the charge. I won't give too many examples. I've seen it in my career, but there were times when people have flailed their arms and yelled. One person was charged with a disorderly conduct. Another person did the exact same thing and got charged with an assault, a much more serious offense. Those are choices made by the charging bodies, and you have to be conscious of that and make sure you're looking at the underlying conduct. I'll say two quick last things I think judges can do. I think you also have to be conscious of your own potential biases because we all have them. I don't think anyone wants to be biased. So when you're aware of it, you stand less of a chance of succumbing to it. I also watched a video by a Superior Court judge who posted a video the other day giving his thoughts on what we can do about it. And I thought he said two things that were really interesting. He talked about not doing the acceptance of responsibility. I don't know if you want to call it reduction because it's often not really a reduction, but really making the same recommendation, whether or not someone goes to trial or does a motion to suppress, not upping or making that sentence worse simply because they exercise their rights.
Who was this judge?
It was Judge Liu, which I thought was something I hadn't thought about, and something that I thought to be compelling. This is a little bit beyond me institutionally, but he also talked about figuring out ways to do lobbies and plea negotiations in less busy sessions because it gives you more time to consider more factors in the case, so you're not moving fast. It's difficult in busy courts sometimes, but I think you have to be willing to have people roll their eyes at you once in a while to make sure that you're taking the proper time, the proper time with the case. Also, bail decisions, I think, play a role because the more time someone's in jail, the more likely they are to plead guilty. So judges have to be mindful of what happens when they set bails that people can't afford, which is not really an issue of race, it's more socioeconomic class, but disproportionately affects people of color. That doesn't mean people aren't still held accountable, but everyone's looking for equitable accountability. And I think those are the things I would try to be mindful of.
So how do you take a defendant that comes from, let's say, Wellesley, a defendant that comes from Roxbury? How do you make a charge fit both fairly? Same charge in each. How do you do that?
Well, it is difficult.
Just finish by saying,
Yes.
because obviously the kid from Roxbury in a much different situation than the kid in Wells.
Yes, sir.
And if you're going to hold them both to the same standard, I would say it would be unfair to the minority member in Roxbury.
Well, it's a little difficult to answer that in the abstract, but I'll do my best. I would say that I would look at the conduct that formed the basis for the charge. So if you're looking at the charge itself, again, that can be misleading. What was the conduct that formed the basis for the charge? That's on a big spectrum. So I think to be fair, you want to look at what each person did. And I think when you're looking at the record, you want to keep in mind that while I think the record does matter, I think it's all about how
Why does it matter?
So I think the record matters because I think in circumstances where if you have someone who might be alleged to have committed a sex offense and they have prior sex offenses on their record, or they're in front of you for a domestic violence case and they have prior domestic violence cases on their record, I think in that circumstance, coming into contact with police more often is relevant, but I think much less relevant than drug offenses, property offenses, or motor vehicle infractions. So I think the record does tell part of the story, just not the entire story. So when I look at someone's...
What the records show, excuse me.
Yes, sir.
From what I've seen, is they show a minority member wherever in Massachusetts with much more interaction with police
Agreed.
than the kid in Wellesley or Longmeadow or one of Weston or one of these other towns. So isn't it unfair to use the record against the minority member because he's living in an area where his interaction with the police are going to be much greater? He's going to get stopped more.
Yes.
As the report said, I believe that people of color are no more violent than white people, but police officers think they are. And that's why they stop them more. Stop them in the car, stop them on the street. So why is it fair to use that record against somebody living under those conditions in the minority areas of our state.
Sure. So your point is well taken, Counselor. And as I said in my initial answer, I do think it is unfair, especially with certain kinds of offenses, to judge someone exclusively based on that prior record and to sentence them far more harshly than someone who might not have been subject to that sort of police interaction. So I do agree with you, especially with drug offenses and other, I don't want to call them minor, but other less serious offenses. I take your point and I agree. And I think with other kinds of offenses that the record does matter more to me. And I think that the interactions with police are a little bit less relevant, although I'm still mindful of that.
So it seems to me that, and I've used records all my life.
Yes.
In the court system. But I've changed my opinion of it. I think it's unfair. I think it leads to exactly what that report has shown us.
Yes.
That's what it leads to. That's one, in my view anyway, one of the reasons why there's so much disparity in percentages of minority members and white members. I don't know of any other reason why it would be that way. Other than that, judge looks at a record. Kid from Roxbury, he's got 5 entries on, he's 22. Well, there's another one. Okay, you're going to jail. Kid from Wellesley, he's got nothing on his record. The police don't stop him. He could be just as bad. He could have committed even worse crimes, right?
Yes.
So we say that when you do your sentence, the judge has ordered you to do, it's over. You paid your debt, right? But not so in the court system. The court system, that record's used again and again and again on people. Do you think somebody that commits a non-violent crime should be incarcerated?
Generally, no.
What's the generally mean?
I think people can have different definitions of what constitutes a nonviolent crime.
I mean, violent. I'm
Yeah,
touching somebody else
I understand.
inappropriately, hitting somebody else,
sure.
using a knife on somebody, some sort of a violent part of a crime.
I think generally, no. And I'll explain the generally in more detail. I think that, for instance, there are times when people can be in possession of very dangerous weapons. I'm thinking of firearms and firearm-related offenses. I think that, technically speaking, it would qualify as a nonviolent offense, but I think that carrying firearms, unlicensed firearms, creates a great danger in the community. So I think there are circumstances where, for a technically nonviolent offense, incarceration might be the appropriate thing. Generally speaking, especially in the district court, I do not believe in incarceration is necessary.
Yeah, the gun issue is a troubling issue. So
Yes.
yeah, I will give you that there's an element of violence or potential violence
Yes.
that would be, the judge should be cautious.
Yes, sir.
But I'm talking about other nonviolent crimes, larceny, shoplifting, things of that nature. Should any people in those categories, should they be going to jail and be put in a cage?
In the overwhelming majority of circumstances, no. There are times where someone can steal a very large sum of money or be someone who has done that often. Now, in many of those cases, those might go to the Superior Court because the amount of money that they took, in fairness. So I probably won't see a ton of people who have embezzled $50,000 in the district court. But
I'm one of them.
Yes.
I come before you as a judge.
yes,
And I embezzled $50,000
Sure.
from a bank. You mean to tell me the only sentence I can get is incarcerated in a cell?
oh, certainly not the only sentence. What I believe is that there are circumstances that it may be appropriate based on the severity of the offense. even though it's nonviolent. I don't think it's the only option. I think more likely than not, in the overwhelming majority of larceny cases, and we've had a lot of them at the Attorney General's office, we have a white collar bureau, and people have embezzled very large sums of money. Most of the cases, and it's gone to me for a sentencing recommendation, most of those cases, I've recommended probation, even when people have embezzled very large sums of money. There are, yeah,
Wouldn't you want the guy to pay the money back?
yes,
Well, how's he going to do it if
if
you
he's
put him
in
in
custody,
jail?
yes, yes, yes.
And when he gets out, he's not getting a job again
No.
because he's had jail time.
Mhm.
And if it does, it's a very low-paying job.
Mhm.
So you're putting somebody in jail stops any restitution that's going to ever come out of this.
Yes.
In fact, for that kind of money or more money, some people might say, look, give me the year in jail. I don't have to pay it back.
Yes.
But I think, and I hope you keep that report from Harvard with you and realize that while sitting on the bench, you have a role to play in how many minorities and people of color and poor people in general, white, black, or indifferent,
Yes.
that they shouldn't be put in jail because of those conditions they live on. At least if it's a nonviolent crime. But in the district court, it's a very low percentage of people that end up going to the House of Correction. Would you agree?
I would agree.
Most people get probation, they do programs,
Yes.
and it seems to work pretty well on the whole throughout the state. So what we don't need, in my view, in this system, is another person in the robe defaulting to jail every time there's a case in front of them that may be a little touchy or whatever. Are you going to be that judge that defaults to the jail?
I certainly would not
It
default.
hasn't gotten us anything. It's costing us fortunes
Yes.
to keep people in jail. We spend more money on jails in Massachusetts than we spend on education.
Mhm.
Is that crazy? Is that ridiculous? You get states that are in the southern states are now realizing that they're letting people out of jail because it's costing too much money
Yep.
for their budgets. So what do you think you as a judge can do to make sure other judges know about this bias, prejudice in our courts?
Well, you have to be willing to speak up about it and share your experiences and be
We're
able.
going to speak up about it. Let's say you're sitting in
Sure.
district court, and in the next session, you know the judge is really not good with this issue, and you suspect there's some bias there.
Mhm.
What are you going to do about it? Are you going to go and talk to him? Are you going to talk to his supervisor? How do you handle it?
Well, I'm not.
That's a tough thing to do.
It's a tough thing to do. I'm not sure, especially coming in as a newer judge, that I'm going to approach somebody and talk to them about how they're handling their session. I think there are other ways to go about it. The trial court, I think, has done a pretty good job of trying to address this issue. And I think that, in the last couple years, the late Judge Gantz, Judge Carey, Judge Dolly reached out to us at Mass Black Lawyers and the other affinity bar groups and tried to start talking about this issue. And more judges are being trained on unconscious bias and being trained on different things to consider while sentencing. And I think those are the opportunities that I would try and use to encourage people to be as fair and equitable as possible.
Do you think the racism issue in our courts has gotten better, stayed the same, or is it getting worse?
So I think that the responses to the racism issue in our courts have gotten better. So I think when I started, which is not, I guess, in the scheme of things that long ago, but 17 years ago when I started, I think that generally speaking, people are much more open to having this conversation. I can say that when my first 7 to 8 years out, I don't recall anyone having this conversation at all. So I think people are much more open to the conversation. They're much more aware of it. And I think the courts have responded. I would point out the SJC has released a couple of decisions recently, the Long and Evelyn decisions, which make it a lot easier to argue equal protection, racial discrimination, and motions to suppress and things along those lines. I think those are real substantive changes that don't force defense lawyers to make a principled argument or a legal argument that actually that now qualifies as a legal argument that you can put forward without having to collect data that isn't there. I think those mechanisms have been helpful. We're not exactly where we want to be, but it's a process. We're not there yet, but I think the response is better. Overall, I would say it's been an improvement.
Have you ever been inside of a house of correction or a state prison?
Yes, in my 9 years as a defense lawyer, 3-4 times a week.
You wouldn't want to live in there, would you?
I would not, sir.
Neither does anybody else. Okay.
Mm-hmm.
And with all the technology we have today, we can put people in their homes under GPSs and we know where they are 24/7.
Yes.
And they're not learning the crime business that they would be if they were incarcerated.
Mm-hmm.
So you brought up drugs. What's the deal with the drugs in your opinion? We've been fighting the war on drugs now, by my calculation, for 51 years, over $1 trillion. Have we gotten anything out of it?
I think that the war on drugs has been proven to be obviously heavily flawed. A law enforcement strategy, a sole law enforcement strategy to solve the drug problem, I think we realized was, for the most part, a fallacy. It's a public health issue. It does involve some law enforcement resources possibly, but we have to treat it much more as an addiction, as a disease, as a public health issue. I think in drug cases, what you want to do, what judges should do is, they should be sensitive, they should be flexible, they should be compassionate, and they should understand that relapse is part of recovery, and we should expect people to struggle. Really,
We don't all understand that.
I appreciate that, and I think that more judges are aware of that now than when I started, and I think that you just have to be careful to give up on someone who's drug addicted and incarcerate them simply because you're frustrated that they can't stop doing something that their brain and their body convince them that they need. So that would be my approach if drug cases came before me. You always want to seek to rehabilitate and help someone turn a corner rather than incarcerate wherever you can.
So here's a hypothetical. You're on the bench. Somebody's been sentenced for possession of drugs. The order is testing for drugs.
Sure.
So a couple months into the probation officer comes in, brings a client in and says he's failed a blood test, a drug test. I want him incarcerated. There's nothing else in the case. Other than that, he's been fine. What do you do with that?
I almost certainly reprobate them, and maybe.
Why is there an almost with that?
Well, again,
I said that's the facts, okay?
So I would reprobate that person.
Okay.
Maybe there are conditions that could be adjusted that help, possibly not. But if I'm hard pressed to think of a circumstance where I would incarcerate someone simply for failing a drug test.
All right. So you do that. 3 months later, the probation officer's back before you. Failed another test. Want their jail time. All there is to the case. Judge White too.
I think in that circumstance, I would do the same thing I did the first time. I just believe, after having so many clients who were drug addicted for so many years, I think there should be an expectation that you might have multiple positive tests, and incarceration is not going to help that person or help the community. If there were circumstances where the addiction was fueling dangerous behavior, then it's a different story. If it's simply a positive test, I think it's more damaging to send someone to jail, even if it's multiple positive tests, especially where someone might be working and still be able to be functional.
You agree with me that some people that are addicted to substances cannot stop that behavior?
Yes,
Physically, they just can't stop.
yes.
So even if somebody has multiple violations of the test, I'm hearing from you saying that putting somebody in a cage for that, and that alone is probably not going to be something that you would do.
Yes, sir.
Is there a dress code for the courts?
There is not.
So somebody comes into your courtroom with a T-shirt, arms exposed, shorts on. What are you going to say to them about it?
Nothing.
Good answer. I've sat in courtrooms and I've seen judges belittle somebody for sometimes a half hour in front of a whole courtroom. And my first thought is to say, why don't Judge, you and this fella go out and back and settle it? Because from up there, you got a lot of protection. You can be a bully to some. And it's clear from looking at the defendant that he probably didn't have any money to buy clothes
Yes.
like we have. And he didn't have probably anybody that taught him how to dress. But I've seen judges say some awful things to people. So I hope I don't walk into a court. And I say to a lawyer, how's Judge White doing? Oh, boy. He's yelling at defendants by the way they dress. I hope I'm not going to hear that, right?
You will not.
School zones. What do you think of the school zone law?
When I started, the school zone law was, I think, within 1,000 feet of a school, 500 feet of a park. It was grossly overexpansive. There was about maybe 30 feet in Boston that wasn't within 1,000 feet of a school, of 500 feet of a park. So you had people who didn't deserve it, who were charged with a hard 2-year mandatory sentence. I thought the changes that were made to the school zone law, I think it was 2008 or 9, I don't recall the year, but I thought that was certainly a smart decision. I think the courts have been better off for it.
It's helpful, but would you agree with me that's one of the most abused laws that's ever been on our books?
I agree.
And there are judges in the BMC, I don't know if there's any left, but there were judges there that would never sentence anyone to a school zone violation because they thought it was unfair, and anywhere in Boston you could be convicted of it.
Yes.
So, in my 43 years of practice, and I probably had less than a half a dozen cases of somebody actually selling drugs in a school building or on school property.
Right.
And it's usually a student who's got some, marijuana, and he's giving it to his buddy, and maybe the buddy's giving him $10, I don't know. But so that it's very rare, but most of the cases are the property, the curtilage of that statute.
Yes.
In a lot of cases, the police, if they're buying drugs, will set it up in that zone. Then the kid gets charged. Like you said, they have the ability to charge, right? So what's Judge White going to do with the school zone issue? Because I'm looking for somebody bold, like the judges in the BMC, that say, no, it's unfair. I'm not sentencing anybody under it.
If someone is convicted after a trial?
Pardon?
If someone is convicted of a school zone offense after a trial?
Well, after a trial.
Yes.
I get that your hands are tied.
Yes.
But not really. Because let's assume a conviction. You say, look, this is so unfair. And I know you're going to be a judge who's going to be fair, right?
Yes,
To the citizens of this Commonwealth.
yes.
So you're now in a conundrum where you know this is an unfair sentence. And you said, hey, geez, I was at the council and I told Jubenville I was going to be fair. This is unfair. So what do you do with that?
If the Commonwealth met the legal requirements for a school zone and someone was convicted, even if I disagreed, I think I would be forced to impose the sentence under the law.
An unfair sentence?
I think the legislature makes certain
No, no, I'm talking about the facts of your case that you're sitting on, and you say this is
Yes.
unfair.
Yes. And I think that even with the facts of that case, the legislature makes certain determinations that you feel shouldn't apply to certain cases, or you don't think this person is deserving. I think you will face that circumstance many times as a judge. I think, though, it's important to acknowledge some of the limitations of what you can do. And I would impose a mandatory sentence even if I didn't like it. I think that's your obligation as a judge.
Be unfair.
I think to follow the law even when it bothers you is your obligation.
So we had a little judge, I call her little because she is little, and she sat in the Superior Court,
Yes.
woman of color.
Mhm.
She had that dilemma. She said, I'm not fair, and I'm not going to impose an unfair sentence. And she gave him, I think it was a 10-year mandatory. She gave him like 2 years in the House, and it got overturned. But guess what happened to her after she did that? Gave an illegal sentence. Guess what happened to her?
Nothing?
Nothing. Because there's nothing they can do to you. Okay? But she made her point. You
Yes.
see what I'm saying?
I see what you're saying.
She made her point. And it took courage to do that. And nothing happens to you. They can't take your job away from you. It takes a long time to get rid of a judge, and it's got to go to the governor. Then it comes here. We'll never get rid of you for doing that.
Yes.
We'll be cheering you.
Mm.
So judges can make a difference by what they do. And even if there's publicity about it, so what? Most people think it is unjust, that school zone. Most people would be saying he did the right thing. So I implore you to be bold. Bold. Citizens are paying for everything. Why shouldn't you help them and be fair to them? So let's assume you're in a courtroom and a lawyer is acting up and doing a few things he shouldn't do or whatever. What are you going to do about that? Are you going to find the lawyer in contempt or lock him up?
No.
You ever hear of a judge locking up a lawyer?
I've seen it 2 different times.
I would much rather have you never sentence anybody under that 2-year school zone and take all the criticism anybody's going to give you, which isn't going to be much. I'd rather have you every day do that than to lock up a lawyer or a DA. Because as soon as you do, that's what you're marked at.
Yes.
For the rest of your career. You'll lose any credibility you ever had.
Mhm.
So if it gets to the point of getting it tense in the courtroom, my suggestion would be to call a recess. You're the boss in the room. You can walk off anytime you want. I'll call a recess, go on the back, relax for a while, and then come back out. But once you do that, you're tagged. It's an awful thing to do. And it won't work anyway, because within 20 minutes of you locking them up, the SJC is going to call you, and they're going to tell you to release them.
Mhm.
And then they're going to know all about it up there. What about probation supervision? You doing any supervising?
As far as I know, I believe so. I'm not really sure about the particulars of it beyond what my clients told me when they were on probation.
Well, I like probation. My daughter works in probation.
Mm.
I don't think they do much supervising today. Most of it is having somebody come in and pee into a cup. And for that, they get the privilege of paying for it, $65 a month.
Mhm.
So I'm pretty sure those fees can be waived, can't they?
They can.
So Judge White's on the bench. You going to waive those probation fees?
Yes.
I don't think there should be any fees for probation.
Mhm.
None. Why are we paying them? They're not even supervising people.
Mhm.
Everybody's paying into a cup. Oh, judge, he failed the test. Oh. So most people that are on probation can't afford it.
I agree.
If they could afford it, they probably wouldn't be before the court.
Mhm.
What about breathalyzer machines? How are they doing today?
Last I heard, not so great. I'd have to read the latest cases and literature on them. I know what happened a couple years ago, but from last I recall that, there was a lot of issues with the breathalyzers.
So it's had a troubled past. Would you agree?
Yes.
A lot of doubt in people's minds about whether those machines actually work
Yes.
and work appropriately. So as a judge and you've got an OUI case and the government wants to put in the breath test, how could you ever put it in with what you know about what goes on? How can you do that?
Well, I think there are times when technology can be improved if there are studies or some improvements made to the technology, then maybe as a judge I would feel differently. As it stands right now, I think most people have their doubts, as do I, about the reliability of breathalyzers. So as it stands right now, I would have a very difficult time admitting it as evidence without some information that there's been some improvements in that technology and the oversight.
Or if you do allow it in, how much credibility can you give it?
If it's a bench trial and I'm the fact finder, I would have my issues with the reliability of the breathalyzer.
Let's assume it's a jury trial. Would you make a lawyer file some jury instructions and ask you to tell the court about the troubled past of that breath machine?
I would ask the parties to help craft some sort of instruction. I think they should have input on what I say to a jury. So I would ask the parties to craft an instruction that I think would be fair to both sides.
I mean, don't you think juries should know about the history of those machines?
Yes.
Well, you'll be on the bench. You're the guy that either tell them, because I'm sure the DA won't tell them. You ever hear of Alford pleas?
I've heard of him, yes.
What do you think of them?
I've never actually seen one. It sounds to me like it would be something that could be helpful. I'm saying that in the abstracts. I've never actually seen anyone do one.
Well, you've seen people do pleas.
Yes, of course.
Okay. So, and the judge says to the DA, would you read the statement of facts? And they read the statement of facts, and the judge says to the client, is that basically what you did?
Yes.
Well, the only difference in an Alford plea is the judge doesn't ask that.
Yeah.
You know that.
Yes.
So what would be the problem with doing the Alford plea if there's a need for it? In other words, a client's in a position or a job that by making an admission, he may lose his job. Making no admission, he won't.
Mm-hmm.
The penalty would be the same. Whatever sentence is going to be given out would be the same exactly, except for that one question. How do you feel about that?
It sounds to me like it can still be a useful tool. I had clients who agreed with some of the facts of the case but disagreed with a lot of the critical facts of the case, but wanted to resolve it, but didn't want to admit to certain things. And Alford plea would seem to be a good middle ground where we could help resolve more cases. I'm just hesitant to say, because it wasn't really used when I was coming up as a DA or as a defense lawyer, I'm ignorant as to the reasons people stop using it. I'm not sure if there was a reason.
Case
Yeah,
where the defense lawyer asked the judge to do an Alfred plea.
I
Did
saw,
you
yes,
object to it?
I did not.
Did the AG or the DA in the case that you were with, did he object to it or she object to it?
I believe so.
Why do you think somebody would object to that?
I think that most people wanted the defendant to make the admission.
No, I know that.
Yeah.
Why though?
I think that there was confusion about whether Alfred pleas were the same as the continuance without a finding, whether you could impose the conviction after. I think there was a lot of confusion as to what the collateral consequences or what the circumstances would be if someone violated their terms. I think it was more confusion as opposed to being against it.
Yeah. Well, this need to have everybody say they did it,
Yes.
I don't understand why we do that, to be honest with you, anymore. This need to have somebody say they did it.
Yeah.
When they're before the court, they've agreed to a plea, they're going to get the plea, they're going to get the sentence. Isn't that enough to recognize that the person knew and agreed to do all that?
Yeah.
You got to have them admit it too. But there are people, even in district court, who are innocent, right?
Yes.
So for that 10 or 15% that are truly innocent, there's no way out for them other than to try the case or plea. So for those people that say, hey, I didn't do it, you've had clients probably said that, look, I didn't do it, I can't admit.
Yes.
And there's no other choice for him other than to try. And if he loses, he might get sentenced harder by a judge for that. So you'd be in a position to get rid of a lot of cases by people saying, look, I don't want to go forward, I want to end it. But I'm just don't want to answer that question. Get rid of a lot of stuff off your docket. It's the holdup in a lot of these things, right?
I agree. Yes.
Couple. Oh, yeah. You applied for the district court in 2015?
I did.
You were
36.
36.
30.
So at 36, you thought you were ready for the judgeship?
In short, yes, with an explanation.
Give me the explanation.
So I had never thought about a judgeship seriously until a BMC judge, Michael Coyne, who I had appeared in front of for a very long time at that point.
You
Well,
listen to Michael Coyne?
I do. I must admit I do. And he called me up sidebar and he encouraged me to consider putting in an application. I actually said to him that, well, I'm not really sure if this is, time for me. And he really thought that I should really consider doing it in short order. And when a judge approaches you and puts that in your mind, that for me was really, really compelling. That a judge I had appeared in front of that many times believed in me in that way. And when I spoke to other judges, they gave me the same vote of confidence. So that's why I applied at that time. But certainly I acknowledge that I'm a better candidate now.
Well, Michael Coyne is probably one of the best judges that ever sat on the bench. So if he said that to you, he knew something about it. Couple of your answers here are on my peeved list. The questions on your JNC application. Question 55, it says, list all organizations to which you belong that are active in lobbying before public bodies and include the names and contact information for the parties involved, period. What's your answer to that?
I think I wrote none.
You put not applicable. I don't get why it's not applicable. It's either yes or no, isn't it?
Yes or no?
Yeah. Well, I wrote not applicable in the sense that I'm not a member of any, so I should have written none. Yes.
It applies, and the answer is either yes or no.
Yeah.
Same thing with 56.
Yeah.
Please describe, and I'm doing this to you because I don't like seeing these answers, and a lot of the nominees are coming in with a whole bunch of the not applicable.
Mhm.
I mean, it's crazy. Please describe any experience you had in the budgeting or personnel management that has not already been discussed in summary of your employment history. Not applicable. Why isn't that applicable? The answer is none.
Well, it said, please discuss. So I was saying I can't discuss because it doesn't apply to me.
No, it says, please describe. Judges have to be good at reading.
Yes.
That's why I never would make a good judge.
In fairness, I think the instructions on the application tell you write not applicable if you believe the question is not relevant to you. I think that's where it comes from.
Well, that's got to stop because everybody could say, you know, all these questions
Yeah.
aren't applicable to me because I don't like saying the answer. Might cause me a problem at the council.
Yes.
You ever had any bar complaints?
No.
You filed all your federal, state, and income taxes.
Yes, sir.
You did give an answer on the amount of monies, certain monies. I'm not going to ask you to state it here, but you didn't really answer that question. And I'd like an answer to that privately. Like
Sure.
that's question 71.
Mhm.
Identify with particularity every entity in which you have any interest, financial or otherwise. What's your answer to that?
Did I write not applicable again?
Yeah. What is it?
None.
Or not? Okay. You attach this motion here.
Mhm.
A Superior Court motion to file an appeal on a motion to,
A denial of the motion to suppress, yes.
why wouldn't you just go up to 11-3 on the Supreme Court?
I thought the only pathway was the interlocutory appeal at that point.
It's a pretty good brief that you wrote. Yeah, a lot of good issues.
Mhm.
I can tell that you're going to be very bold on the bench, which is a good thing, in my view. You know why? Because you made no bones about it in this motion. How basically the judge didn't know what the heck she was talking about. Motion judge's finding on this point is based on a series of blatant factual errors. That's a pretty bold statement. Then you said it one more time. So that's a good thing for you to be bold like that. The judges make mistakes too, right? They get it wrong.
Yes.
So I thank you for your time, and you're going to be one of the best looking judges on the bench with a robe, that's for sure. And that's big. Okay.
Best dressed.
Thank you, Mr. Chair.
Dina Iannella.
Thank you very much,
Yeah.
Mr. Chairman. I had a lengthy conversation with the nominee. He answered all my questions. Counselor Jubenville asked a lot of the questions that I was going to ask. I have no questions. Like I said, they've all been answered. Your Counselor Kennedy, is a strong supporter of yours. He speaks very, very highly of you. Great educational background. You have the great experience, and I think you're going to be a great addition to the district court when your name comes before the council. I'll be more than happy to support you.
Thank you, Counselor.
Thank you. Counselor Devaney.
Thank you. Oh, nice to see you again.
Good to see you,
Thank you
Counselor.
for all the time you afforded me. I feel like I know them all personally. First of all, I wasn't going to mention it, but the school zone law,
Yes.
and Councilor Jimville brought that up, so I thought I would follow up on that. It's something I will always remember and I will never forget, and it really hurts me to see what happened to a very nice person. I've been lobbying for commutations, pardons for years up here. We're not getting them, you know that. But we did have a commutation during Governor Patrick's administration. And it was a 57-year-old white man who came before us. And I will never get him out of my mind what happened. I believe when the school zone law started, it was 5 years and it changed to 2 years. We're talking 50 years ago, because this man was 57. And when this happened to him, he was 17. He was 17, he was on the way to school. And an older friend, 22 years old, stopped him and said, "Would you do me a favor? I got 3 bags of marijuana here. Would you sell them for me, 25 cents a bag?" Naive, innocent, good person, good son, good student, naive. He took those bags, he went into the school, and he sold one. Then when he approached another student to sell it, the student refused and reported him to the principal. Principal went to his locker and found the other bag.
Yes.
So he went to prison. And he gave up his youth, graduation, school dances, sports, maybe a scholarship to college. And when he came out, he married, had children, was a very good community person involved, coaching, did a lot of good things. Unfortunately, his health, he had cancer, he lost a leg, he's gone through a lot. And when he came out of prison, fortunately, he got a job in a private school as a custodian. Well, guess what? Now he's before us. Yeah, he'll go on his way, he's pardoned and all of that, but he has no job. And even at 57, without that baggage, where do you go? So I always had him in my mind that I thought, I believe in discretion for judges. Okay.
Yeah.
And I thought, I have to believe if that judge had the discretion, maybe he could have given him community service, probation, he could have given him anything, but not put him away. And I think of him so often, I don't know where he is or what happened to his life, but I thought how unfair, because the judge could not use discretion. So I just wanted to say my experience with that. That's the only, I'm not a lawyer, that's the only connection I had. And I will always look back on that and say, justice wasn't served. So having said that, I always ask the nominee about your journey coming here.
Yes.
So we'll go back. You were 36 years old and you applied for the district. 2 years later, and you were rejected.
Yep.
And then 2 years later for the Superior. And then the next for the municipal.
Yes.
Now, so did you go to the JNC or it was just denied you're altogether or what?
I went to the JNC for the first time on my third application.
Okay, so you were denied the 3 times.
Yes.
Now, I want to talk about this time. For people who don't know, there are 21 lawyers that a governor chooses for the awesome responsibility that I'm all alone, no governor's counselor has,
Yes.
okay? Everyone thinks we have so much authority. We only vote yes or no. I don't know how many people applied. I only know yes or no. So I only know you to vote yes or no. But when I think of the responsibility they have to decide if you're going to get an interview and to recommend you to the governor for a lifetime position. And guess what? This JNC chair has thrown that out. He's not interviewing 21. 21 people are not interviewing you or any nominee in this whole Baker administration. And that's wrong, because that is an awesome responsibility to investigate, to know. So in fact, we're having lawyers who are voting for someone, never saw them, never talked to them, never called them, don't know them, and voting for them for a lifetime position. It's wrong. Just as for history's sake, years ago, there was a former JNC chair, and he sat down, those 21 lawyers, and said, if you don't go to the hearing, you don't vote on the nominee. That's justice, okay? I have found out things, unfortunately, along the way, a few nominees, egregious things that were removed. JNC didn't see it. That's their job. That's their job.
Mm-hmm.
So I just want people to know. So in fact, I know you were going through the pandemic, so it's a lot different now.
Yeah.
So how many people interviewed you at your hearing?
This time around, it was about, I'd say 9 or 10.
Okay. You see my point?
Yes.
You see my point, how wrong that is? And it bothers me. And I bring this up only, not for you. Please know it has nothing to do with you.
Mhm.
But I want the public to know the process. They have no idea. They think that we have all this authority and that we choose from a bunch of names. Not true. But I believe how it used to be in former administrations, 21 people meet, 21 people make a decision to recommend to the governor. But, I do want to say, really, you were young to be, to think about being a judge at that time. But I want to tell you, and for the public, you're here now. And I know there are political nominees that jumped the line, and that's why it took a little while for you to get here. So I do want to say that, and I want you to know that. And I want to thank you. Thank you for reapplying, because I've been here 21 years, and I've seen some outstanding people who become judges who have been rejected 1, 2, even 3 times, and they kept applying. Because like I said, political nominees jumped the line. And I'm so grateful that you persevered. I don't usually show my hand, don't have a poker face, but I can't be more pleased. It was such a pleasure to learn about you. The reason I meet with you and everyone in 21 years, I'm voting for the whole person, not just someone on a paper. I want to know you and what brought you here. And obviously, it's your family.
Mm-hmm.
And I'm first generation American like you. And I know that your parents and my parents went through discrimination. And you know what? And I can say it for your parents and my parents, they were the most patriotic. So having said that, I'm going to get off my soapbox. So, okay, so now, I was very impressed with your writing, your sample. It was so easy to read. And I want to give you the opportunity to tell the public about the defendant, Lorenzo Jones. Would you tell us about that case?
Well, Mr. Jones had some sort of verbal confrontation with a man on the street that he had never met, began yelling at him and saying disparaging things. They had a kind of a standoff, and then Mr. Jones began to flee away from that person to try to get away from the circumstance. He went to a friend's house, went inside the friend's house to get away from this guy. The person called the police, said Mr. Jones had threatened him. When the police came, they didn't find any weapons on him or in the house. They then searched a mailbox in the apartment building, a triple-decker in Dorchester, where they have common hallway mailboxes. And in an old mailbox, they found a firearm. And the police then charged Mr. Jones with possession of that firearm and assault by means of a dangerous weapon for threatening that person with the firearm.
And the result?
He was found not guilty.
Now, I talked to you about a lot of your cases,
Mhm.
and I'm going to ask you now, is there one that you feel really justice wasn't served and you were disappointed in the outcome?
Yes, the one I often think about is it's in my application. It's the case, Brandon Campbell is the defendant's name. He was in a car with several people, well, two other people, not several people, two other people. There was a shooting out of the car and everybody ran, and he was ultimately convicted of participating in the shooting and also possession of a firearm. That triggered a 5-year sentence for him. I truly believe that he was innocent, and he was charged under what we call joint venture or joint enterprise, aiding and abetting. He wasn't actually accused of shooting at anyone or directly possessing a gun. And it bothered me because I think he was with the wrong people at the wrong time. That's a cliche.
Wrong place.
The wrong place, wrong time, wrong people. It's a cliche. In that circumstance, I really believed it actually applied, and he lost 5 years of his life. And I didn't think he was someone who was deserving of that. So that's the one that probably stays with me. Every loss haunts you, but that one probably the most.
Right. How about Corey Patterson?
Corey Patterson was a person I represented in a murder case. He had a fight outside of a bar in Brighton with another person, and he was convicted of stabbing that person one time in the chest. And unfortunately, the young man died when he was stabbed in the chest. Mr. Patterson and I had a unique relationship. I had actually prosecuted him for a firearm offense when I was a DA. And then he called me and asked me to represent him when I was a defense lawyer. And in between that case and the firearm case, he had went to college, out of town. He was doing well, had this fight. He was convicted of second-degree murder. And I had gotten to know him, seeing him every week at the jail for 2 years. He is going to serve the mandatory 15 years, then you'll have a chance of parole, and we'll have to see what happens. But that one certainly stays with me as well.
Right. This is a very naive question, but someone carrying a knife, would you question that? He had a knife with him, or he found a knife? I don't know.
Yes. Well, it was our contention he did not have a knife with him. Certainly someone who's carrying a knife. I think you can question that. Some kids feel they need it, but oftentimes it causes more trouble than it's meant to solve.
Yeah. And, we talk about how when people are released from prison,
Mhm.
what is the follow-up? In my 21 years, it will always be my regret because I went to the funeral for Police Officer McGuire, who Sinelli, as we all remember, had 3 lifetime sentences, which amazes me. It was only 15 years considered a lifetime. But anyway, he had 3. And I'll tell you very openly, I voted against the chair, and he ultimately released Sinelli. And Sinelli killed Officer McGuire when he was out, shortly out of prison, and he was at a holdup, and he in a jewelry store day after Christmas, and he shot Officer McGuire and killed him. I investigated, and I found out there was no follow-up for Sinelli. No follow-up. He was let out, and supposedly he was supposed to meet his probation officer once a week. He was put into an internship to be a plumber. He was to live with his uncle and pay rent. None of the above. None of the above. And so from that experience, sad experience in the life of a police officer, I have been asked that we follow up and make sure that they're doing their job, okay? So having said that, I want to tell you that I'm very pleased you have 99% criminal experience. That's fine with me, because I believe you can learn civil on the bench. My fear is for a judge who has been an attorney, has never had criminal cases, is a little timid when he has a criminal before him on how to deal with this. So I just want to say that. Now, you were a member of the Police Accountability. Okay, so what is your position on police defunding the police?
I do not believe in defunding the police.
Okay, good for you. I do too. And you know what? I'm sitting here thinking, yesterday, the trial started for Sean Gannon, a 32 young officer who was answering a call because this career criminal had violated his probation. And that criminal shot and killed Sean and shot his canine dog. And, you know, Sunday I went to the police memorial out here that we have.
Mhm.
Hundreds of names of police officers that have been killed. They've been killed in the service of protecting people. I don't see any billboards. I don't see any marches for these good police officers. And why are they held as the type of people who never should have had a badge, never should have been on a police department, and that have killed innocent people? Does it make sense to you that they're held to the same level? I don't get it. But I hope these people who are trying to defund the police will go over to that memorial and see those names. Because got a lot of good, dedicated police officers. And those others, they should get the most sentence that's possible for what they've done. So having said that, I like your experience that you've gone from, different departments. And most recently in your job, tell us your responsibilities.
So I'm currently the Deputy Chief of the Criminal Bureau at the Attorney General's office. So the AG's office is comprised of bureaus, and each bureau is made up of several teams. So I help oversee the entire bureau, and that's about 8 different teams. So I oversee financial investigations, victim services, white collar, enterprise and major crime, gaming enforcement, appeals, and I'm probably missing 1 or 2. So that's a lot of them. But what the main focus of my job is obviously to support the chief of the unit, but also to oversee sentencing requests and to oversee requests for indictment. So before anyone proceeds against anyone on a case, they have to get our approval to investigate that person, and then approval to go into the grand jury, and then approval to what we call vote, meaning actually charge that person with a crime, and then approve all sentencing requests. And a big part of my job was also advising the Attorney General on different policy-related issues.
Well, I tell you, the Attorney General sent a wonderful letter, and it wouldn't be my position to read it. I know your district, I know that Councilor Kennedy will read that. It was very good. I liked your writings. A lot of people don't have writings, and I like that title. Now talk about that.
Which title?
You had a writing of, I'm gonna have to go look for it. You must know about it. It's I don't know. It's just fairness, police.
Oh, was it the lessons for African American lawyers?
Yes.
Okay,
Yes.
so that actually was not my writing. What it was, they reached out to different Black lawyers across the country, and they asked us to write basically testimonials and give advice and contribute to sort of an anthology where we could encourage college students, high school students to go to law school or learn more about law school. So I wrote my piece of it, but certainly didn't,
I think it's great.
Yeah.
We can't say enough about drugs, what's happening.
Yeah.
Years ago, no one really cared. It was in Roxbury, or it was in, other parts. It wasn't in Dover, Wellesley. And now people are paying attention, but it's not enough. And I have been lobbying. I think, I don't know if it's changed, but the judicial was getting out of the budget here, 1.5%. We don't have we don't have drug treatment centers. I've had 2 friends who their sons died of overdose of heroin. And I know one of them very personal, the son, who really tried, but they don't have a long-time placement. And they don't want to go to Concord. They don't want to go to a prison. And I think the women only have one. I think they only have one place. And so I'm saying, could you, as a judge, join with other judges and lobby here and tell them the need for long-time placement? A weekend, a week is not going to do it. I know these young men. They have gone to the short term. Their parents have gone to classes, and it doesn't work. We need more. Now, I hope you can do that. On the other hand, I've gone to drug court, and I just want to know what it was about.
Yeah.
I went to a graduation. Oh my God. I sat in the back. Tears came to my eyes. It was so moving that these people of all ages would testify and talk about how they went through that drug program and they graduated. And some of them, 30 years, were drug addicted, and what they've done with their lives. It was very impressive. What do you think about the specialty courts?
I think the specialty courts have been a blessing to the court system. I think the drug courts overall have been very, very good. It helps to give people who are addicted the attention that they need, the support that they need, and they get to know the judge, and the judge gets to know the people.
Right.
And that's what makes it unique. I know at the BMC, we also have a veterans court at the Central Division. We have a mental health court also downtown. So I think the specialty courts should be expanded, and I think overall they're very, very good.
But we do need, I think we only have 3 or 4 drug, placements. We need more. I mean, this is not right. But yeah, no, we certainly haven't won the war on drugs, that's for sure. So, what do you see going into this district court that you're going to be assigned to? What do you see that you would like to change to make it better?
Sure. I think the district court could use more staffing. And what I mean by that is more mental health workers, more substance abuse counselors, more interpreters on the civil side, more mediators. I think that a lot of the sorts of cases that come into the district court are problems, obviously, of society that come into the court. And many times people need a different kind of support than an appointed lawyer can give them. So when I was doing appointed work for many years, I used to wish that there was a social worker that I could bring a lot of my clients to. They obviously couldn't afford it on their own, but I used to wish that there was a social worker I could have them talk to, a mental health worker. They are available and they do a great job, but they're overworked. And if we could have more, I really think that would be helpful to the courts.
How about witness advocates?
Yes, victim witness advocates are very, very important to the courts, and they obviously are overwhelmed too by the amount of cases that come in.
Have you had much dealing with the Children and Family Department?
Not directly. My wife has handled those cases for several years, but I haven't handled those cases directly.
I'm very concerned about it.
Yes.
Very, very concerned. When you find a baby in a bag and the mother saying she's with the grandmother or whatever, and she walks free and the boyfriend goes away. I know, I understand the system, but I think that person should, because they were part of it. They saw the beating, they saw all of it, you know? But I do want to mention in your position because you had to rattle them all off. So I want to just say some of your responsibilities. You oversee 9 different divisions: white collar, public integrity, gaming enforcement, human trafficking, financial investigations, appeals, enterprise, major and cybercrime divisions, as well as victim services, Massachusetts State Police Detective Unit, and the Digital Evidence Lobby. And what you just said, and I won't go over it.
Yes.
It's your responsibility to oversee all of this. How much are we seeing in human trafficking, and is that increasing?
I think in the last few years, we've seen an increase in human trafficking cases. When I started, very few district attorneys' offices had human trafficking units. In the last 4 or 5 years, most of the DA's offices now have units just dedicated to human trafficking, as well as the AG's office has a unit that we focus on human trafficking cases as well. So I think we have seen an increase. Now, I'm not sure if it's because we're better at investigating these things and we're more focused on them, but I've certainly seen more human trafficking cases in the last 5 years.
Now, how would you deal with someone with a mental issue? You have been involved in that in your position.
Yes, many times.
Tell me, how would you proceed?
So it would depend, but generally speaking, if someone has a mental illness, what you want to make sure is they get evaluated, right? That they see a court psychiatrist, a court therapist, or if they want funds to get an independent evaluation, that's fine too. And you want to make sure that they're evaluated because the mental health workers then come out with a very detailed report explaining some of the background of the defendant and some of the challenges that they have in decision making, in criminal responsibility, and things of that nature. That is extraordinarily helpful to not only the judge, but when I was a lawyer on cases, they would find out things that my client never told me because they were trained to find those things out. And I think we also have to be conscious of people who have undiagnosed mental illnesses or other sort of developmental challenges. One of those is autism, being on the autism spectrum.
Right.
I had several clients who I saw their brains worked in a way that was different, and it caused them to react in ways that you might find inappropriate or odd, but
Right.
it's them processing the pressure.
Oh, like
court.
Asperger.
Yes, absolutely. And I think you have to be. I've gotten better at recognizing that. I'm not an expert. I've gotten better at recognizing it, and I think you have to be mindful that informs the way people act and behave.
Right. So the thing that's so horrific, and it's increasing, and it's mothers that are involved too. Murders, child abuse in murder.
Yes.
How much have you been involved in that?
I have been involved in child abuse cases as a defense lawyer.
I don't know how you go home at night. Honestly, it's horrific. Well, look, I'm not going to. There's so many other questions I want to ask, and my colleague has asked a lot of questions, but I just the other thing is it's incidental, but I see other nominees sitting in your chair that put not applicable, and it drives me crazy. Because if I asked you if you were in the military, you don't say not applicable. If you are, you don't. So that's the only thing. And I'm not going to hold that against you because others are following suit. Whatever someone said you could put in A, everybody's putting in A. So anyway, but it was such a pleasure meeting you and obviously your family, and they've influenced you. And that was it came through when I met with you. And I hope you'll bring them all to the diner.
I will, Counsel. Thank you.
I thank you, and thank you, Counsel, for the time.
I believe we have Counselor Hurley on WebEx if she's available.
Good morning.
Counselor Hurley?
Can you see me and hear me?
We can't hear you. Your microphone's muted, I think.
Oh, we have Zoom? I thought we were not allowed. That's good. Good. That's good. That's good. That's good.
We think we have. All right. Andy, you want to work on that? Now calling Counselor Duff while we try to fix it? Counselor Hurley? Counselor Hurley, can you hear us?
Can you hear me?
We can, yes, go ahead.
In any event, I told the nominee when I spoke to him at length that because of the problems with my back, I've been advised by my doctor not to travel to Boston for a few weeks. And that will hopefully resolve my problem. But after speaking with the nominee at length and reviewing his application, I find that he is absolutely qualified for the position of a district court justice. And we talked about my 20 years on the bench, and the sage advice that I gave him was the first day he shows up for work, make sure you've got the black pearl. In any event, in reviewing your application, you are involved in a tremendous number of community or law-related committees and programs, etc. Do you understand that you got to review your membership on those when you become a judge?
Yes, Counselor.
And it is best that you do those with Chief Justice Dolly, so that you don't get any conflicts for yourself or do anything that would be considered an ethical violation. These are the kinds of things that new judges don't usually have an awareness for. I think you're going to do a great job. I think every question and then some that I would have asked you, or that we have an opportunity to discuss on the phone, has been answered by you today. So I wish you the best of luck. And I will be voting for you in person. Hopefully without the pain in my back. Thank you.
Thank you, Counselor.
Thank you, Counselor Hurley. Counselor Duff.
Thank you. Thank you for applying and for sharing your family and everyone with us today. I do have a few questions that haven't been touched upon, and they're things that you and I spoke about when we did speak. One of them has even come to light in this morning's press, and it's something that, as I shared with you, I'm very concerned about and have been since I come here. And that was the report that came out today from DCF about LGBTQI kids.
Yes.
Have you had a chance to learn anything about that?
I actually saw the article this morning in the Boston Globe.
Yeah, it's stunning. It's unfortunate. And I hate to say I was right, but it's the type of thing I've been talking about from the beginning. So, have you any experience working with this community, particularly this community of youth?
Yes, not juvenile specific, but I have had clients who were LGBTQ plus, who were young adults that I represented that had previously gone through the DCF system.
Okay. You know, and I've said many times, concept of the hub court system. I think it's a brilliant idea. However, until we have a really comprehensive public transportation system, it doesn't work. Because if you can't get to court, then you don't have access to justice, and we don't have justice for all. It's really that simple. And I personally try to bring things down to that real basic level, because I think it makes sense and it makes it easier for people to understand. I think you're a terrific candidate. This is the first time I've met you. I've spoken to you. I've known about you. I've followed you. I haven't stalked him. But you know, you have a fine reputation, and I think you'll be a stellar, even though you're young, you're not that young. I think you'll have a stellar career, I hope, and you will be a wonderful asset to our justice system. So I don't know, is your wife, what are you doing? Do you want to apply?
We got something else.
We need some more women.
We got something else in mind for her.
Okay, but anyway, thank you so much for stepping up. It's a lot. I want to reiterate again. I mean, I talked to you a little bit about the safety issues. You shared with me some experiences you had with being threatened when you worked on different cases.
Sure.
I find it appalling that anybody, particularly any elected official, would threaten or publicly criticize a judge for a decision that they don't agree with or understand with, because to me, that's a real violation of separation of powers. I witnessed it when a judge in my district, a Superior Court judge, came under great criticism for something he did, a reading of the law that he did that people didn't understand. Interestingly enough, it was a very conservative judge, and people were calling him every kind of name they could think of, trying to paint him on the left. I can't ascertain why the man did what he did, but I respect it. And I know that I spent an entire day in that court talking to traumatized court workers who had been threatened, and people protesting outside houses and verbally attacking their families. It's not civil, and it should not be done, and it should not be accepted. And I'm sorry that I even have to have that conversation, but I think it's a real conversation that we have to have. A man like you, with your aptitude, your intelligence, and your education and your drive, can clearly be making a heck of a lot more money doing something else other than public service. So I thank you and I salute you for choosing this path, because there are many other paths, frankly, that I think would be much easier for you and for your family. So thank you. That's all I
Thank you,
have.
Counselor.
Thank you,
Duff.
Counselor.
Couple of things. First of all, who told you you were too young to apply when you're 36 and 38?
A man named Terry Kennedy.
And you were. You agree now? A little bit?
Yes.
Okay. Now, one of the things that I've talked to the governor's office about, and that I've mentioned many times, is that we absolutely have a problem with diversity on the bench. And we absolutely have a problem with not enough members of the diverse community of lawyers applying. And I said, the one thing that they have to give up if they want more diversity on the bench is age. Because when I went to law school, when Counselor Juvenville went to law school, there wasn't a lot of diversity in our classes. So when you go to look for people that are 55 and 60 years old, that are lawyers from the legal community to apply, if you want older people, you're not going to find as much diversity there, because they weren't in law school like they are now. And that's why we have to take that into consideration, just like you have to take into consideration things, issues of implicit bias when you're on the bench. The reason we don't have as much diversity today in terms of an older crowd is because of bias that went on when I was younger, admissions to law school. And I just want to point that out. I'm not going to be long. I'm going to point out one pet peeve I have with prosecutors, with probation officers, and especially with district court judges. Something that happens over and over and over. And I tell them when they're on the bench, and I tell them when they're off the bench. There are two sides in every case, right? There's a defendant who has a lawyer usually, and a prosecutor, right?
Yes.
And that defense lawyer and prosecutor are supposed to be on equal footing in that courtroom, right?
Yes.
Today, we have so many people put out on pretrial conditions of release, including many of my clients. It might be blowing the breathalyzers, it might be taking urine screens, it might be curfews, whatever they are, right? You see it all the time. And over and over and over again, I find out when I show up for trial that my client flunked a urine or a breathalyzer a month ago. There was a warrant issued for his arrest, so it's not on for trial anymore. And nobody told me. Some prosecutor goes into the room or a probation officer says, Judge, this person flunked a urine or this person missed a curfew, and they go get a warrant for him. Well, the last time I checked the rules, before you bring a motion before the court, you're supposed to notify the other side. Usually there were motions. There's certainly not anything that appears to be any type of emergency. Happened to me this week. I have a case on for trial in Barnstable at 9 o'clock Monday morning. My client called me today because his machine didn't work. He called his probation officer, says, oh yeah, you flunked one, so we put a warrant for you and we don't use the machine anymore, which is counterproductive because you still want them blowing in the machine afterwards, right? What sense does that make? And there's certainly no great danger because nobody's going to get them. You know what I mean?
Yeah.
So what's the point of all that? Nobody told me. My client found out because when we went to blowing it, he called the company that runs it. Oh, you're off. And then he called the probation officer. Do you think that should ever happen, that they should be able to go in ex parte like that with no prior notice to defense counsel?
I think the better practice is to notify defense counsel.
What do you mean better practice? The only practice, read the rule.
Yes.
The rule is I get notified when you bring something in the court.
Mhm.
Look, if there's a serious domestic violence
Yes,
case,
that's what I
and
mean.
somebody cuts off a GPS that's there to keep them away from the victim,
Yeah.
okay, bring that emergency motion.
Yeah.
Try to get a hold of me. We got great things these days. We have Zoom, we have WebEx, we have cell phones. I'm not hard to get a hold. You ever have trouble getting a hold of me?
No.
Okay? No, it's easy today.
Mhm.
You send somebody, everybody, I think in the Commonwealth of Massachusetts has my cell phone in the court system.
Mhm.
You know? Text me. We're bringing your case forward. I'll pop on the Zoom if I'm not in the area, I probably can do it. Even in here, I can step out and do it. And it's a pet peeve of mine, and I bring it up with judges over and over and over. And what they say is, well, I asked them, did you notify Attorney Kennedy? Or make sure you notify Attorney Kennedy. That's not enough.
Mhm.
Why aren't you summoning the person in if you're not going to arrest them? Why aren't you just summoning him in on the warrant? Instead of bringing a warrant, say, bring him in, I want to see him. Call his lawyer, I want him here next week. Because they put out these arrest warrants. Sometimes they get arrested. That can be dangerous for them. It can be dangerous for police. It can be dangerous for everybody. When a phone call, I'll bring him in. We'll pick a convenient time. You know, sometimes they get arrested, and then what happens is I'm standing there and the DA says, well, we're not asking that they be revoked, but we want you to address the issue with them. Why don't you summons them in
Mhm.
with notice to me? And I am not exaggerating. It happens to me twice a month. And I bring it up over and over with judges. You know, I talk to a lot of judges. It falls on deaf ears. Are your ears deaf when it comes to that?
No, sir.
Okay, what are you gonna do when a probation officer, it's not probation surrender either. That's a different issue. There's issues with that, but probation officer walks into you on pretrial conditions. This guy flunked the breathalyzer, judge. We want a warrant. What are you gonna do?
I'm going to say that you should contact the attorney on the case, and when you've contacted the attorney, let me know.
Are there too many revocations of bail in the state right now for minor offenses?
Yes, I'd say so, yes.
Yeah, I think there's too many motions brought, and I think there are too many people revoked. I've spoken to some district court judges who revoke people on, you know, somebody has an assault and battery and they get picked up for
Yes.
operating after suspension. They'll revoke them, and their philosophy is, well, there should be some penalty for the new crime.
Mhm.
Well, that may be true, but why don't we wait to see what happens with the new crimes? You know what I mean?
Yeah.
You know, but they just automatically revoke them whenever there's a new crime.
Yes.
and a lot of people end up in jail. That's less so because of the pandemic, because there's other issues that have come out there. Obviously, they were a little less hesitant to, but it's something that they do. What about too many 58As? You think there's too many 58As? I'm going to adjourn this because we're going to get stuck here.
I have a lot of questions.
Huh?
Oh,
What's the, I'm sorry. Do you think there are too many 58As filed in Massachusetts?
From what I've seen, I think so.
Yeah, way too many, I think.
Yes.
Yeah. Okay, I'm good. I'm gonna recognize Council Ferrara if he has a couple of things to say. Or take all afternoon. We'll
Thank you,
see
Mr.
later
Chairman.
on.
You're going to lunch?
Yeah.
All right, thank you. So I actually don't have any questions. You and I spoke at length. You come with great recommendations. The chairman over here is a big fan of yours. He's a big advocate. I've talked to a lot of people, done my due diligence. I think you're going to make a great judge. One thing I will say, and I won't ask you any questions about it, because I know you just came from working for the AG's office, but the reason I'm late, I just spent over 2 hours with the people that are doing the Court Officer Academy investigation. And when I scheduled it, we weren't going to have this hearing this morning, so I apologize for being late. But I just want to give the email to anyone out there who's watching, because I know historically for the last 3 weeks, there've been 1,000 people watching our video. So I can say that I just met with Nancy McGilvery. Her email is Nancy, MCGILLIVRAY18 @gmail.com. It's a personal email. So people have called me, a lot of people have called me, thinking that if they email her, the government's somehow going to know, and they're worried about retribution. But this is a personal email. No one will know that you email her. And you can, whoever wants to can have a conversation with Ms. McGilvery. I met with her and another gentleman. I think they're very legit. I think they're going to do a great investigation. It's going to be fair and impartial. And I'm just encouraging anyone who wants to reach out to them to please do. So thank you. You have my support next week.
Thank you, Counsel.
Council Ferrara.
Thank you.
And we're going to close the hearing. You're going to be a fantastic judge. I already know that. I know you well professionally, and you've done a great job in every role you have. You have a lot of fans out there. We have a letter from Attorney General Healy. I know that she wanted to speak today, but because there were a conflict, she was unable to do so.
Yes.
And I spoke with her on the phone about you at length as well last Sunday. Kenny Desmond, huge fan of yours. He called me up in 2018 when he didn't get through and yelled at me. It's not the first time I've been yelled at by him, but that's okay. So I look forward to voting for you hopefully next week.
Thank you, Counsel.
Adjourn.
Thank you.
Excuse me, just one
What time
question.
are you going to start? 1:30? Or are you going to wait? Marilyn,
Counselor Hurley, we will be coming back shortly for the next hearing, so stay on the phone.
are you going to start at 1:30 or should I tell people later? Okay, 1:30, all right.